1.03. What should be stated? Everything should be stated in an indictment which is necessary to be proved. Heard further asserts that 37 Texas Administration Code 3.23, 3.6, and 5.2 was to be included in the indictment in order to charge him with Texas Penal Code Section 49.04, which discloses the following. 37 Tex Admin Code Section 3.23, Citation and Custody Arrest. A citation. All traffic law enforcement officers of the Department of Public Safety will cite or arrest, as appropriate, all violators of the traffic laws apprehended by them who are committing a clear, cut and substantial violation of the traffic laws unless major extenuating circumstances are present. B. Custody arrests. 1. Custody arrests should only be used a. when necessary to have a violator forthcoming in court, b. to protect the violator or the public from injury, or c. when required by law. 2. Under no circumstances will a custody arrest be used to punish the violator or as a convenience to the trooper. In obtaining information for a notice to appear in court, the violator is required by statute to furnish his name, residence address and date of birth. It is desirable to elicit pertinent information such as occupation, telephone number, and business address, etc., for possible future use in the processing of warrants. However, the violator's failure to respond in the latter instance is not, standing alone, a sufficient reason to make a custody arrest, for they are not legally compelled to provide such additional information. 37 Tex Admin Code Section 3.6, Crash Investigation Policy, a responsibility. The Texas Highway Patrol Division of the department is assigned the responsibility of investigating and properly reporting crashes involving motor vehicles which occur outside the city limits of an incorporated city upon a public road, highway, or other way or place open to the use of the public. B. Investigating and reporting. Upon notification of such crash, officers of the department will, insofar as practicable, make an on-the-scene investigation and properly report the results of their investigation without regard to the severity of the crash. See crashes in cities. 1. The department will not investigate motor vehicle crashes which occur in cities except in emergencies or where prior arrangements have been approved. 2. Any commissioned member of the department who witnesses or comes upon a motor vehicle traffic crash within the city limits will notify local officers and turn all information and control of the investigation over to them as soon as possible, pending the arrival of the local officers. Such department members will seek to protect the scene, render first aid or summon medical aid, detain involved drivers when necessary, and take any other action immediately needed for the public safety for which he has been trained and is equipped to perform. 37 Tex Admin Code Section 5.2, Conduct of a criminal investigation. An officer or other member of the Criminal Law Enforcement Division may conduct a criminal investigation when adequate suspicion exists that a crime has been, is being, or is about to be committed. The investigation shall ascertain the facts. 1. To determine the existence of a reasonable suspicion to support the temporary detention of a suspect for further investigation or identification. B. Probable cause to support a search or arrest warrant. Or C. Probable cause to support the warrantless seizure of property or evidence or the warrantless arrest of a suspect who is committing or has committed a crime. Or 2. To take lawful action to prevent a crime from being committed. B. An officer or member who is conducting a criminal investigation shall be primarily concerned only with an investigation within the specialty field to which the officer or member has been assigned, except 1. In an emergency situation, or 2. When instructed to participate in a special investigation by a supervisor. C. No officer or member may investigate a public official without proper authorization of the director, the assistant director, or another individual expressly acting in the stead of the director. In United States v. Mirsky, 361 U.S. 431, 437 438. 1960, it is disclosed by the Supreme Court the statute is not complete by itself, since it merely declares the range of its operation and leaves to its progeny the means to be utilized in the effectuation of its command. But it is the statute which creates the offense of willful removal of the labels of origin and provides the punishment for violations. The regulations, on the other hand, prescribe the identifying language of the label itself, and assign the resulting tags to their respective geographical areas. Once promulgated, these regulations, called for by the statute itself, have the force of law, and violations thereof incur criminal prosecutions. just as if all the details had been incorporated into the congressional language. The result is that neither the statute nor the regulations are complete without the other, and only together do they have any force. What's more, what this court has allowed the government to do is to withhold exculpatory information from the grand jury by not supplying the information disclosed in 37 Texas Administration Code 3.23, 3.6 and 5.2, which results in a violation construed with Brady v. Maryland, 373 U.S. 83, 1963. The greatest description of the suppression of information in such case is explained in Pyle v. Kansas, 317 U.S. 213, 215 216, which phrased the rule in broader terms. Petitioner's papers are inexpertly drawn, but they do set forth allegations that his imprisonment resulted from perjured testimony, knowingly used by the state authorities to obtain his conviction, and from the deliberate suppression by those same authorities of evidence favorable to him. These allegations sufficiently charge a deprivation of rights guaranteed by the federal Constitution, and, if proven, would entitle petitioner to release from his present custody. Mooney v. Houlihan, 294 U.S. 103. The principle of Mooney v. Houlihan is not punishment of society for misdeeds of a prosecutor but avoidance of an unfair trial to the accused. Society wins not only when the guilty are convicted but when criminal trials are fair. Our system of the administration of justice suffers when any accused is treated unfairly. An inscription on the walls of the Department of Justice states the proposition candidly for the federal domain. The United States wins its point whenever justice is done its citizens in the courts. 2. A prosecution that withholds evidence on demand of an accused which, if made available, 8888 would tend to exculpate him or reduce the penalty helps shape a trial that bears heavily on the defendant, that casts the prosecutor in the role of an architect of a proceeding that does not comport with standards of justice, even though, as in the present case, his action is not the result of guile, to use the words of the Court of Appeals to...
Okay.
Yeah.
Good.
I sure appreciate it, man, because when I got to looking at all those regulations, I was like, every single piece of this regulation has a compound part in order to go ahead and convict the person. So if you're in a grand jury, you're going to have to expose that to the grand jury that all this was done in order to go ahead and to make probable cause to bring the action.
Exactly. And and if you ain't got true knowledge of what's going on, you in the blind.
Exactly.
And then that affect your Fifth and Sixth Amendment rights to the Constitution. Mm-hmm. And if it's on the federal side, it's in violation of Federal Rules of Criminal Procedures C1 and C2 because they're using it to your prejudice by not citing the regulation in your indictment in the first place. You know, so like I said, I'm sitting here talking to somebody right now at the moment that is dealing with a case in the state of Ohio. Okay.
Right.
So in the state of Ohio, I was explaining to him that his indictment don't have the regulation, but if it did have the regulation on it, the regulation would have defined, since it's a drug charge, that a doctor, physician, or pharmacist had to be a part of his indictment. And because they're not a part of his indictment, then his cases should be dismissed for lack of jurisdiction. So now, we're looking at what you've done on your situation for your client, where his case is a traffic stop. And the regulations inside there is telling them, even if they go so far, only thing that they can do is ask for your address, telephone number, and this and that and the other so they can send you information. They can't tell you to get out the car. They can't tell you to do none of the things that they've been doing and tricking people into situations when they don't supposed to. Like pulling them over and turning around and telling them they got to have they're going to take a dog and take it around his car, which violates his Fourth Amendment right to privacy.
Right.
You get what I'm saying?
Yeah.
Well, just ask him.
You're actually doing a search. That's a search.
Right, within itself. So even telling him to step out the car, he don't have to step out the car. Because the only thing he's doing is giving them a ticket. So if he give a person a ticket, the ticket, he ain't got to get out the car to give him a citation. And a citation is nothing for him to arrest him over.
Right.
You know, so